My name is Melissa Pachola. I'm the Director of Pro Bono and Community Partnerships at Legal Aid Chicago. And I want to thank you for coming to this training for the Eviction Brief Advice Desk. Let's orient ourselves to the plan. We're going to spend a little bit talking about the Eviction Brief Advice Desk and how it works and how you can volunteer. We're then going to talk some law because we are lawyers after all, and we should talk about the law. We're going to talk about eviction law and court procedures, including how someone gets evicted in the court process. And then we're going to get into more details about how the Eviction Brief Advice Desk works, your role there, and how you can volunteer. At the end of this, you will be equipped with everything you need to know in order to start volunteering at the Eviction Brief Advice Desk and to help tenants stabilize and prevent homelessness. So what are we doing here? Why does this matter? I want to point out to you in particular that middle particular circle that states that 11% of renters in eviction court have legal representation, while 79% of landlords are represented. What that practically means is that whenever a tenant walks into eviction court, or in these days, shows up on an eviction court Zoom, they are facing a power imbalance. And the reality is that the power imbalance they face is actually carried over from their actual tenancy. By providing tenants with something as simple as brief advice on court procedures and their rights, you're helping to level the playing field. Why does this matter now? Yes, you've heard it, you've seen it on the news. We are on the precipice of an eviction crisis. 21,000 households in Chicago are at risk of eviction once the moratorium have lifted, and they have. That's compared to 30,000 evictions that are filed in Cook County annually. So we are facing the avalanche, tsunami, crisis, all of those terms that you've heard. It is happening now. The good news is that you can help. So what does the Eviction Brief Advice Desk do? And we lovingly refer to this as EBAD. I often joke that EBAD is E-good. We provide brief advice to tenants virtually over Zoom. And as volunteer attorneys, you'll consult with tenants in the Zoom rooms to help them understand their rights. You'll review proposed agreed orders that their landlords and their landlord's attorney has sent them. If you're able to, you'll negotiate on behalf of tenants, and you'll also make referrals for further extended representation to Legal Aid Chicago. The Eviction Brief Advice Desk assists tenants from any district in Cook County that are facing eviction. So that includes not only the downtown Daly Center, but the 5 suburban courthouses that surround us. By the magic of Zoom, we're able to connect with all of these tenants at once. You'll meet with clients in breakout rooms using Zoom. And again, participation requires only brief advice, coaching, document review, a little bit of document prep. If time permits and you are willing, you can negotiate on behalf of that tenant to help them resolve their case. And there's no expectation ever that you'll stand up in court or provide full representation to the client. Legal Aid Chicago attorneys are on site real time to provide you assistance with your case. So what does that mean? It means that Legal Aid Chicago attorneys are actually in the Zoom with you, waiting to provide advice to you after you consult with your client. This is a graphic that talks about the logistics of volunteering at the desk. So we get the referrals, Legal Aid Chicago gets those referrals, and what we're doing is we're screening them to make sure that they're appropriate for receiving advice at the Eviction Brief Advice Desk. We're going to screen them out to make sure they're not accidentally a landlord or they're not in foreclosure and that they're not already represented. We then make an appointment for that client to meet with you. If you are somebody who has what's known as a known conflict, right, that there are certain types of plaintiffs, in this case, that you would absolutely not want to be advising against, what you can do is you can let us know that, and we will not set appointments for clients who you may have that conflict with. Once that appointment is set, you will meet with the client and you interview with them, and you will provide either advice or other brief services, including referrals, possibly representing them in negotiation or in mediation. And then after your shift, you will send your notes to Legal Aid Chicago so we know what happened and we know about any next steps that we need to take. So now that we've talked about the very basic logistics of volunteering at the advice desk and understanding its role, let's talk about eviction law. The rights of tenants in eviction court are actually a smorgasbord of an intersection of federal laws, state laws, and local laws. And it is nobody's expectation that you will have read or memorized any of the laws on this list. But I do think it's important to lay out that we're not just talking about one particular type of law, and we have to understand how these laws might interact with each other to provide the tenant rights. The main ones that apply are sort of bolded here, right? We've got the Eviction Act, which lays out the court process for the most part for tenants. And then we've also had the moratoria that have applied during past months. Chicago has its own residential landlord tenant ordinance, and so does Cook County. Those are really the 3 or so laws that act to sort of provide most of the rights for tenants, but you can see that there are more available. I mentioned Chicago's RLTO. The purpose is to provide tenants some rights and also to protect landlords as well as to preserve housing. The RLTO applies in most situations, but not all. And the main exception is when there are 6 units or less in a particular building and the landlord lives there. So that's a conjunctive statement, meaning that both things have to be true. There's an exception to the exception, which is that the prohibition on lockouts applies to all units regardless of size or who lives there. Lockouts are the concept of changing the locks or making the apartment otherwise inhabitable for the tenant while they have a legal right to be there. Cook County got in on the game this year, effective June 1st, with its own residential tenant landlord ordinance. And what the RTLO does is it extends many of the Chicago-based protections that we're all familiar with, or some of us are familiar with, to residents of suburban Cook County. It similarly does not apply to owner-occupied units that are 6 units or less. And there are other exceptions, just like there are in the RLTO, for hospitals and dorms and other sorts of short-term arrangements. Again, similarly, owner-occupied units are still subject to the lockout provision. But some of the rights that are created both in the Chicago ordinance and the Cook County ordinance are creating a procedure to withhold rent until building conditions problems are addressed, so long as the tenant follows the proper procedures. It protects against lease terms that waive your basic rights to notices and other things. You'd be surprised how many form leases there are out there that say, okay, by signing this, you say that we never have to provide you notice ever. The Cook County ordinance now prevents that and protects tenants against that. It prevents landlords from charging outrageous late payments, late fees, similar to the one in Chicago, or other interest rates. And it also creates some protections against non-refundable move-in fees, which are becoming more and more popular as an alternative to a security deposit. I mentioned already the Eviction Act, which governs what used to be known as forcible entry and detainer cases. And one of the things that act does is it actually creates the right to a trial by jury, and either the landlord or the tenant can request the trial by jury. There's a couple of municipalities in suburban Cook County that have their own residential landlord tenant ordinance. The way to think about these is that if just similar to how federal and state laws interact, the Cook County residential tenant landlord ordinance will act as the floor, and local municipalities are free to enact laws that provide further protections. So for example, the Evanston RLTO actually provides additional notice time in particular, and we're going to see how those compare to the normal notice times in just a second. Before we do that though, a little interlude on different types of housing. So generally, whenever we speak about evictions, we always want to figure out, is the tenant living in subsidized housing or private housing? Subsidized housing is sort of the umbrella term that we use to refer to some sort of rental assistance flowing to the housing or to the tenant. Subsidized housing includes traditional public housing, right? So those units or buildings that are owned by a public housing authority, such as the Chicago Housing Authority. It also includes things that are what we often refer to as a Section 8 voucher, right? Which is a voucher that allows someone to pay less than market rent in the private market. And then other types of rental assistance that may exist, including low-income housing trust fund, senior housing, other types of housing where there's some sort of assistance to a help. When you're meeting with a tenant, we'll often have identified for you whether or not the tenancy is subsidized or not, because we'll have screened the tenant. However, if you're talking to somebody and this comes up, there's a couple of ways to tell. One way is that the plaintiff will often be the Public Housing Authority, Chicago Housing Authority, or the Cook County Housing Authority. But that's not always a foolproof way to tell, as just like many entities, the CHA and the Housing Authority of Cook County have contracts with property managers to actually subcontract out those management of those units. The biggest way to tell is often that the rent that the tenant is paying is below what you would consider market rent. So for example, if you are speaking with a tenant who is paying $300 in the city of Chicago for a 2-bedroom, 2-bath apartment, you can be pretty well assured that that's not market rate, and you should be asking some questions as to figure out if there's some sort of subsidy flowing to the apartment. And then of course you can ask the tenant. Most tenants do know if they're receiving some sort of rental assistance, and they're often very knowledgeable about the provisions thereof. The reason this matters is because if a tenant is evicted from subsidized housing, they will often lose their subsidy, often as a result of the rules related to that subsidy. So if you are evicted from public housing, you can no longer rent in public housing at all. You'll be sort of put on that list and you'll never be able to get such an apartment. And the tenant is likely to become homeless. Why? Because if they were paying a reduced rent and that's what they could afford, then it's unlikely they'd be able to come up with the money to all of a sudden rent in the private market. So as a result of that, subsidized tenants are almost always referred to Legal Aid Chicago for possible representation. Now, to be clear, we cannot take every case that is referred to us, but we do always want to consult about whether or not this is a case that we might be able to provide further assistance on. When thinking about an eviction, there's a basic timeline that is helpful to consider. So we are going to talk about steps 1 through 4 in detail during the rest of this training. But I am going to not talk in length about step 5 or step 6, so I'll take the time to talk about them now. An eviction starts with a termination notice. There's then a complaint. The tenant is then served with summons, and then there's a court appearance. Just like most litigation, most eviction cases settle. If they do not settle, that's when there's likely to be a trial or a follow-up court date if there is a settlement. At that court date, the court can enter an eviction order. They can actually dismiss the case, or they can find in favor of the tenant. Only after an eviction order is entered may the sheriff actually come out and execute on an eviction order. So just a few minutes ago, we mentioned the prohibition on lockouts. This is particularly important because even if a landlord is holding a eviction order that is signed by the judge, they are not entitled to enforce it. Only the sheriff may do so. And the sheriff may come out as soon as 1 week after the eviction order is entered. Sometimes they may come out a few weeks later, depending on how many people are ahead of them and how many orders they have to execute. Importantly, during the last few months, while the eviction moratoria have been in effect, the sheriff has not been executing any eviction orders, for the most part, with some very, very small exceptions. So even if an eviction order was signed, the landlord could not enforce it or ask the sheriff to because the sheriff was refusing. That moratoria have lifted, and so the sheriff is now enforcing eviction orders. There are some additional protections that were extended to tenants as a result of the COVID-19, and we're going to talk about some of those, but you can also see some handouts that are provided to you that may provide additional protection. So getting into step one, a termination notice has to be served upon the tenant to start this process. So termination notices are basically governed by how much time the tenant has to cure or respond. So generally, the most popular type of eviction notice is a 5-day notice, which is given to a tenant when rent is due for non-payment of rent. There are certain requirements associated with a 5-day notice. They always have to be dated. They always have to include the unit number, and that's true across all of these notices. What's unique about the 5-day notice is the following. The 5-day notice has to list the amount of rent owed by the tenant. So demand a rent proper, an amount certain as to how much the tenant owes. And it has to give the tenant the opportunity to pay. If the tenant pays the full amount owed during the 5 days, then the landlord cannot pursue the eviction action. Right? The tenant has cured, and therefore the landlord cannot move forward. One important thing to note here is that it is not uncommon for tenants to dispute the amount of rent owed or to be able to pay a portion, but not all of the amount demanded. Almost every 5-day notice issued will include language that says something to the effect of, only full payment of the amount demanded here will cure this notice. So what does that mean? It means that if the 5-day notice demands $1,500 and the tenant gives the landlord $750, let's say on day 3, the landlord at the expiration of that 5 days will still have the right to pursue the eviction action and keep the tenant's money. A 10-day notice is for breach of lease. And similarly, it has to include the description of the unit, which is just the unit number and the date. And it also has to give the tenant 10 days to rectify or cure the breach. So this typically involves some kind of material breach of the lease, and the tenant has to be given the opportunity to stop that breach. So the classic example that's easiest to think about is if the lease says that there are no pets allowed, and the landlord gives the tenant notice that they have a cat and therefore are in breach of the lease. Technically, the tenant could get rid of the cat within the 10 days, tell the landlord that they have done so, and cure the breach. As a practical matter, I should tell you that no one ever gets rid of their pet. People are understandably very attached to their pets, so they're unlikely to cure the breach there. However, there are other examples like that, like smoking, for example, if you agree not to smoke. One other thing to note here is that the provision of the lease must be what's known as material, right? So I did have a case where the tenant was accused of breaching the lease by putting a coin slug in the coin-operated washing machines. While this was unfortunate and my tenant was sorry for having done it, I argued that it was not a material breach. There was no damage to the washing machine done, and therefore not a basis for eviction. The next type of termination notice is what's known as a no cause or non-renewal eviction notice. And this gets a little bit complicated because of new protections and new provisions of the law. It's either a 30-day notice, a 60-day notice, or it could be actually 120 days notice. This is basically when the lease is coming to an end, or the tenant has a month-to-month lease, the landlord saying, I would like you out, right? At the end of this particular notice period. It similar to other types of law, This is no cause, not bad cause. So for example, the landlord can evict somebody for no reason at all, or give them a termination notice for no reason at all, but they cannot evict them for a bad reason, right? So if they're using the 30-day notice as a potential cover up for retaliation, which we'll talk about later, that would be improper. The big thing that comes up here with regard to no cause eviction notices is actually that people often give notice in the middle of the rental period and fail to give enough notice of the eviction, okay? So an example is the easiest way to illustrate this. If on October 15th, a tenant is given notice that the landlord gives notice saying, I would like to not renew your lease, or I would like to give you notice that I'm not going to further continue this tenancy. And let's say they gave that person till December 15th. Well, the issue there, even though they've given them 60-day notice as is required in suburban Cook County, the issue is that December 15th, if the tenant pays rent at the beginning of the month, is actually in the middle of the lease term. So the tenant actually would have the right to say that's not a proper notice and could stay a little bit longer until the landlord had the time to issue them another notice. There are 90 days notices. In particular, we have here saying refer to legal aid. Typically a 90-day notice either indicates that the property is in foreclosure or it's a particular type of subsidized tenancy. Chicago enacted something called the Fair Notice Ordinance, which extends the amount of time for tenants to no cause eviction notices in particular circumstances. So if the tenant has lived in the apartment for more than 6 months, but less than 3 years, they're entitled to 60 days notice for a no cause eviction or a termination of a month-to-month tenancy. If they've lived there for more than 3 years, they get 120 days notice. And the same sort of rules apply for raising rent. So if the landlord is attempting to raise the tenant's rent, they have to give them similar notice. Service of a termination notice can occur in basically one of 4 ways. You can hand the termination notice to the tenant. You can engage in what's known as substitute service, which is leaving the notice with someone 13 or older who resides at the property. You can send by certified mail, as long as you have the return receipt, also known as the green card. And you can post on the premises, but only when no one is in actual possession of the apartment. So this comes up a lot when we're interviewing tenants and you ask them, how were you served with the termination notice? How did you get it? They will say, oh, it was just on my door, or my landlord slid it under my door. Technically, that's not proper, but let's get into those technicalities for a second. So many people will think that posting the notice is a defense to an eviction action. It's much more complicated than that. And what I would say is it's likely not to be a reason that the tenant's going to win their eviction case. Basically, the landlord can say, yes, I tried to do it properly. And as long as the tenant actually received the notice, most courts will say that's fine. But according to a recent case, the landlord does have to sort of show that they tried to serve the tenant in some other way if they were in actual possession of the apartment, right? So I came by twice, nobody was there, then I posted it. And most courts will say, okay, as long as the tenant actually received it, then it's okay. So not the panacea of a defense that we were once hoping for. There is a procedural issues checklist that is provided in the volunteer guide that's available to you. But a couple of common things that come up with regard to notice. So sometimes you will ask a tenant, what kind of termination notice did you get? When did you get the termination notice? How was it served on you? And the tenant will say, never got one. Here's the deal. Most times the landlord will say, yes, I did serve a termination notice. And now, as we'll talk about in a second, the notice is required to be attached to the eviction complaint. So if there is a notice out there, it's probably attached to the complaint. And if the tenant did if the landlord is saying, yes, I served it, that's probably enough. So you should actually consult the complaint to see if an eviction notice is attached, which will be provided to you if we have it. In most cases, we will. So you can determine if there actually is a notice that the landlord was claimed. There is a defense of a defective notice. For example, if the cure period was too short, they gave somebody 3 days instead of 5 days. And again, that non-renewal, the no-cause eviction, can actually be considered okay if the case wasn't filed prematurely. So if in that case, in the example I gave where the eviction notice is served October 15th to terminate December 15th, if the landlord didn't actually file the eviction case until January 15th, then there's a good chance the notice is going to be fine. And then of course, there's premature filing, which is filing before the expiration of the cure period. So in that same example, I serve an eviction notice that's dated October 15th, supposed to give 60-day notice, and I go ahead and file my eviction case on November 15th. That is premature filing and likely cause for dismissal. After the termination notice has served and the amount of time as required in the eviction notice has expired, the landlord can file the eviction complaint. After the notice period expires, unless of course they were barred by a moratorium, which in this case no longer applies in most cases, landlords will typically name any adult who lives in the property as well as a catch-all known as unknown occupants, which is basically like, if there's anybody else living there that I don't know of, they're included. Landlords can file a single action, which is just seeking possession of the property or the actual unit, or a joint action, which seeks possession and rent owed. The eviction complaint is shockingly simple. Maybe not shockingly, but it is very, very simple. All it says is that the plaintiff is entitled to possession, that the defendant unlawfully withholds possession, and that if there is rent owed, how much they owe. As of July 27, 2020, the complaint must actually attach the termination notice alleged to be served upon the tenants, okay? And if it's for a for-cause eviction, for example, for a breach of the lease actually has to be attached, or the relevant portions of the lease actually have to be attached. If for some reason the landlord does not have an eviction notice, they have to attach an affidavit explaining why, which will hopefully be illustrative as to what's going on in this case. And if the notice or the affidavit is not attached, then the tenant can actually ask for the case to be dismissed. So this might be the very, very nice defense that we were all hoping for. If there's no notice, then it's likely a case that can be dismissed. There is something called sealing the record, which is suppressing it from public view. And in particular, the importance of doing so is to suppress it from the view of creditors and future landlords, meaning that it's not available via public access. Eviction cases filed between March 2020 and March 2022 are automatically sealed upon filing. And unsealing is allowed in only very particular circumstances. This provision is set to sunset on March 2022. We don't know yet if it's likely to be extended. We hope that it is, because it provides very, very nice protections for tenants so that they're not subject to people seeing the eviction action while they're trying to move while the eviction action is pending, right? So it's very, very common for a tenant to be seeking a place to go because their landlord is evicting them and unable to find a place because of the pending eviction action. So this makes it a little bit easier for tenants. It also helps with negotiation. There are also provisions that allow certain records that were filed prior to March 2022 to be sealed, and those provisions sunset on July 31st, 2022, unless of course they're extended by the Illinois legislature. After the eviction case is filed and sealed, then the tenant gets a chance to be served with summons similar to all types of litigation. A couple of particularities about being served in an eviction case though. So similar to other cases, there's personal service, substitute service, and then constructive service. one of the things about eviction summons is that the tenant is only required to be served 7 days in advance of that first court date, which is shorter than many of other types of litigation. So they get about 7 days notice to figure this out. The other thing to remember is that if a tenant is served by constructive service, which is also known as posting, then remember, because there is no personal jurisdiction attached, then no money judgment is allowed unless, of course, the defendant appears. So no personal service, no no personal or substitute service, then no money judgment is allowed. So this is something to consider when speaking with tenants who have not been properly served. And you'll see that there's a procedural checklist in your materials that lays out these defenses in a little bit more order. After being served, the tenant actually appears in the court case and there is a court date. So here is a picture of what eviction court looks like. Not as many people there as there once were because most court is happening via Zoom. So after being served a summons, a tenant must appear in court or they risk a default or an ex parte eviction order being entered against them. Pro se tenants appear remotely via Zoom on the return date, which is the first court date, and may be asked to be referred to something called the Early Resolution Program, which is managed by a case manager from the Center for Conflict Resolution. And we're going to talk a little bit about that in just a second. Speaking of service, if there is no service, but the tenant steps up anyway, or says on the Zoom, I'm here, I'm here, I'm here, they may actually risk submitting to the jurisdiction of the court, which they may or may not want to do. And if the tenant is not named in the case, then stepping up in front of the judge may result in their name being added to the complaint, even though they weren't previously on it. This happens a lot in a sublease situation where the landlord believes they are that Joe Smith is living there, but Joe Smith has sublet to Sheila Jones, and Sheila Jones steps up in the eviction case and says, wait, I live there. Landlord goes, great, what's your name? Sheila Jones. Sheila Jones is not a plaintiff in that case, a defendant in that case. So a little bit risky if there's no service. So I mentioned the Early Resolution Program. It's also known as the Cook County Legal Aid for Housing and Debt Program. So this is launched in November 2020. And the idea is that it connects unrepresented landlords, yes, landlords, tenants, debtors, and those facing foreclosure with legal assistance. Tenants can actually be referred in court or they can call outside of court. Every eviction and consumer debt case now starts, that first court date is a case management court date scheduled for 30 days from the date of filing. And before any substantive orders are entered, the case is evaluated for connection to legal aid resources. So the tenant can actually ask to be referred to the Early Resolution Program, and the court can actually suggest a referral. Legal aid agencies, including Legal Aid Chicago, but not just us, provide advice and brief services to assist in the resolution of a case. And the focus on these services is to resolve these cases quickly and to be able to allow the court to operate efficiently, meaning that those cases that are likely to settle are not taking up court resources. There is more information if you're interested in learning more about the program. So what are the tenant's options once they go to court? On that initial first court date, that is the first appearance, which is before the judge and the case manager, if both parties are unrepresented, then they're likely to be referred to mediation services, or both parties are going to be tried to be connected with legal aid partners. Of course, if the tenant says, I don't want a referral, then they won't get one. No one's being forced to consult with legal aid at this point. If the landlord has an attorney, but they are unrepresented, then they can be the tenant can be referred to legal aid. And once they're referred to legal aid, there's sort of a couple options there. They can negotiate a deal with the landlord in mediation or with a volunteer attorney's help. They can seek legal assistance for extended representation or rental assistance before the next court date. They can file a jury demand, which we talked about briefly, or they could say, hey, I'm ready to go to trial. If it is not the first court date, meaning it's not that first case management date, it depends on what happened last time. That will determine the tenant's options, right? So if the tenant appeared previously and said or did something that may have indicated to the judge that they don't want a referral to the early resolution program, they may not get one. If the tenant filed a jury demand, then the judge is likely to transfer that case for that jury demand and not proceed any further. So it really does depend what happened last time on what the tenant's options are going to be at the next court date. I mentioned already that most eviction cases settle, but I don't want to sort of skirt over the fact that tenants still have the right to due process. You can engage in discovery, you can demand to see the plaintiff's evidence, you can present your own evidence, and you can examine witnesses. They're summary proceedings, but they're not just sort of not entitled to any due process at all. As I mentioned, most cases are resolved in one of two ways, either through a move-out agreement where the tenant is agreeing to move, or a pay-and-stay agreement where the tenant negotiates some sort of payment plan to be able to catch up on the rent owed. And most landlords' attorneys and most judges will say, let's resolve this, right? We want to get this resolved. So let's talk about what are some of the options for negotiation. If a tenant wants to move, meaning they're willing to vacate the apartment, typically we're talking about time, right? It's an agreement to move by a date certain in exchange for possession of the apartment, and often in exchange for waiver of the back due rent. So if a tenant is moving, then they're likely to want to be moving to avoid paying any of the back due or future rent. In an ideal world, if the tenant wants to move, the case should be dismissed after the tenant moves out. And if the tenant has a strong defense or counterclaim, then they may actually be able to get paid to move. Maybe a waiver of additional back rent, more time, or maybe all of those things. There is a standard court form that is used to memorialize a move-out agreement, and you can actually see a sample in your volunteer manual. If the tenant wants to stay, then we're in what we call pay and stay land, right? If they have the money to pay the back rent and can pay going forward, or they've been approved or are willing to apply for rental assistance, it's likely possible to negotiate a pay and stay agreement. One of the things that I always mention is that the agreement should state clearly whether and what rental assistance is being used, when the tenant will pay, to whom, and how much. I have seen a couple of deals really fall apart based on the fact that the tenant didn't realize who they were supposed to pay, or the landlord and the tenant were disputing about whether the tenant did pay based on one of those small details. These negotiations can be difficult if there is a dispute over the amount of rent due, right? If the tenant says, no, I paid you January, and the landlord is insistent that the tenant owes it. This also comes down to the fact that many landlords want court costs and attorney's fees to make them totally whole after they've had to file an eviction case. So if the tenant has the money to pay it, that may work out. If not, this can be quite challenging when negotiating a pay and stay agreement. Good news is that both the Chicago landlord tenant ordinance and the Cook County landlord tenant ordinance provide the tenant the right to stay in the apartment if they pay all of the back rent owed and any court fees that the landlord has paid before the time that the court has entered an eviction order, right? Signed that eviction order. This does not apply if it's an owner-occupied unit with 6 units or less, but this is a great right for tenants who might be able to come up with the money. And for those of you who are wondering, court filing fees for the landlord are somewhere between $250 and $300 or $400, depending on where the eviction case was filed and whether or not the sheriff was used. So somewhere around $300 is what I usually say is the cost of court fees. So when making a deal, and when you're advising tenants to make a deal, or when you're about to make a deal, a couple of things to always keep in mind is don't sign an order that is actually an eviction order. That's essentially losing, right? You will see landlords draft deals on eviction orders that they'll say, well, we'll just sign it on this, and then I won't send it to the sheriff if everything works out. What will happen is that the eviction order will actually show up on the on the court docket and will essentially be like the tenant lost. You have to think about what resources are available. Can the client move and how much time do they need? Do they have money to pay, including the court costs? You can review any proposed orders with the client. You can also draft the agreed order with the samples that were provided to you. Agreed orders should always say whether or not the tenant's going to move or stay, whether the tenant will pay rent and how much, what constitutes a breach of the agreement and what are the consequences of that breach, if there's a waiver of claims the tenant may have, a compliance date, meaning a time to come back and determine if the landlord and tenant have both complied with the agreement, and if it's dismissed pursuant to a pay and stay agreement, how long does the landlord have to reinstate the case? I mentioned the right to trial by jury. So parties in eviction actions have the right to request a jury. The tenant must file a jury demand before the first court appearance in front of a judge, or the right to jury is deemed waived. So this is a little tricky with the early resolution program. Some judges are saying, well, if you come to the first court date and you haven't filed your jury demand, then I'm not going to honor it elsewhere. Some judges are honoring that jury demand after that first early resolution court date. So it depends, but if the tenant wants to file a jury demand, we say advise them to do it as quickly as possible to be able to preserve that right, hopefully. And once a tenant files a jury demand, the case will be transferred out of eviction court and assigned a new courtroom with a different court date. New courtroom meaning not one of the eviction courtrooms, but a jury courtroom. There is information on how a tenant can file a jury demand, included in your materials and on the next step sheet. I'm about to go through some of the defenses and counterclaims that a tenant may have. I want to put these in context for you. Your role as the volunteer attorney is to help identify potential defenses and counterclaims in your interview with the client and your review of the documents. You will consult with the Legal Aid Chicago attorney on the strength of those defenses. In most cases, without going to trial or a contested hearing, a tenant will not win their case because of a potential defense. Sometimes defenses and counterclaims are the basis of a referral for extended representation, but most often they're useful leverage in settlement. So this is the grossest slide I've ever made to talk to you about disrepair or conditions issues. There are basically two types or three types of defenses based on conditions issues. We bring this up because many tenants will tell you about the bad conditions in their apartment and want to use that as a defense, okay? So there is a common law defense called the implied warranty of habitability. And what it is it's an affirmative defense, but to assert it, the tenant has to show that the landlord was on notice and given reasonable opportunity to repair. Most courts will require this to be in writing. The landlord will have failed to repair, and this is the big one, the reduced value of the property exceeds any back rent owed. So if the client owes $8,000 in back rent, and the condition they had was that there were ants one time, it's unlikely that the reduced value of the property exceeds the back rent owed. Right, so that's where this one gets tricky, but it's definitely a defense that can be asserted based on the bad conditions in an apartment. I have had clients who unfortunately were living in places without any working plumbing. And that was a time where I relied on the common law defense of implied warranty of habitability. Both the Cook County and the Chicago ordinance provide a proper procedure to follow for the tenant to actually have this type of defense. So they may have a defense to the eviction if they provide the landlord with written notice of disrepair and the landlord failed to repair. They have to give 14 days written notice for regular disrepair issues, and they can actually give 24 hours or 72 hours notice for what we call lack of essential services like heat and electricity. So if the tenant followed all of those procedures and then did not pay rent, then they may actually have a conditions defense, but that's assuming that they're able to prove that they did everything right. There's also a defense related to the Residential Right to Repair Act, which is that the tenant may actually repair the defective condition themselves, only if it's pretty much less than $500. And the tenant has to give the landlord 14 days to do so, pay for it themselves, and then provide the landlord a receipt. And there's a couple of other exceptions here that apply. Other types of defenses are waiver, which is that the landlord accepted rent or executed a new lease after expiration of the termination notice or after filing the case. This is tricky if the tenant has only paid partial rent pursuant to what we talked about there, but the idea here is that the landlord has acted inconsistent with the filing of the eviction case and therefore may have waived their particular right to pursue it. This may also apply if the landlord has participated in a rental assistance application or actually accepted rental assistance. You can check with the Legal Aid Chicago attorney who's available to you to determine how to check the status of a rental assistance application and figure out if it's gone through or if the landlord participated. Another possible defense is that the tenant tried to pay and has proof of the attempt to pay during the 5-day cure period notice, but the landlord would not accept. And again, remember that the tenant can actually pay the full amount owed up until enforcement of the eviction order and potentially have the right to stay in the apartment. And retaliation is a defense if the landlord takes adverse action, including filing an eviction case or issuing a termination notice against the tenant after the tenant has engaged in protected conduct, such as requesting repairs or contacting the city or calling 311. There may be a partial defense there based on retaliation or a total defense based on retaliation if you can prove it. We mentioned other defenses and claims. These on this list are basically counterclaims, which you can often use to offset the amount of rent owed. So a lockout, if the landlord did something like change the locks, remove the doors, shut off the utilities, typically the tenant is entitled to 2 months rent as damages for a lockout. So if they can show that, then maybe they can offset the rent due. The landlord entered without proper permission. In Cook County in Chicago, the landlord has to give 48 hours notice of an intent to enter. If the tenant has actually been paying for common utilities, which is not as uncommon as you might think, there may be a potential to, and the utility tap law actually gives the tenant particular types of damages. So if the tenant has proof of that, again, they might be able to offset, they might be able to get additional time to move, they might be able to get paid out. And then of course, if there's security deposit violation. To be clear, this counterclaim for security deposit can only really be used as leverage. Enforcement of this actually does require the filing of a separate lawsuit. So many of you have been hearing about moratorium and how they apply to eviction cases. So since April 2020, there have been a variety of state, local, and federal orders that have prevented eviction actions. They actually may not be the absolute bar that they seem to be, and each tenant's situation must be reviewed into detail, including when the notice was given and when the case was filed. For the most part, most of these protections have now expired, but there are a few that still apply. So if you encounter a tenant where a case was filed during the pendency of the state moratorium, which were in effect until October 3rd, then you should consult with attorneys from Legal Aid Chicago to determine how to proceed in next steps. The one protection that I was indicating still does apply, or one of them, is the Chicago COVID-19 Eviction Prevention Ordinance, which basically it is in effect until December 2nd, 2021, unless, of course, it's extended. And this applies if eviction notice was given to a Chicago tenant from March 21st, 2020 onwards. And what it basically triggers is that it's a 7-day after the landlord serves an eviction notice upon someone, they have to give them a tenant notice of COVID impact. If the tenant returns such a form and says, yes, I've been impacted by COVID-19, it triggers a mandatory 7-day good faith negotiation period between the landlord and the tenant. So this does not require that the landlord and the tenant reach a deal, but it may provide the following protections. So if the landlord did not give the tenant the notice of COVID impact, then the case should be dismissed because the landlord was required to. If the landlord gave the tenant the notice, then you should ask the tenant about what negotiation they have had with the landlord and consult with the legal aid Chicago attorney. And again, the question here will be whether or not the landlord negotiated in good faith, because the act doesn't actually require that they reach an agreement. But if the tenant tried to reach out to the landlord during that period and the landlord said, I'm not talking to you, I'm waiting for my day in court, then there's an argument that the landlord did not in good faith negotiate, and there may be a cause for dismissal of this case. During every consultation at the Eviction Brief Advice Desk, you should inquire whether or not the tenant has applied for or received rental assistance. There is rental assistance available, and the time for applying and how much money will be available and how the tenant can access varies depending on the type of assistance they may be eligible for. For City of Chicago programs, we can actually check the status of a particular rental application and refer directly for assistance applying. For Cook County programs, we can actually refer directly for assistance again, and that program is prioritizing tenants with a pending eviction case, which may be very helpful. And there was also state-based assistance available. This is a little bit trickier, but we still want to know if the tenant received it or if there's a pending application out there. And the receipt of rental assistance by the landlord may provide a limited defense to the tenants, but this varies by the case and the type of assistance received. So how does the Eviction Brief Advice Desk work in the context of everything that we've just said in all those laws? So again, your responsibility as a volunteer are to review court documents, notice and proposed settlements that are provided to you. You are to provide the client with information about the court process, their settlement options, and attorney referrals as appropriate. You're to send the case notes to us after your shift. And if you have time, and if you are interested, you can negotiate on the tenant's behalf with opposing counsel or represent them in mediation. So you remember this slide from the very beginning. You may not remember it at all, but these are logistics of volunteering at the desk. We take the referral, we make the appointment, you conduct the appointment, and you send us your notes. You sign up for a shift via Sign Up Genius, and the link is here, and we can also provide it to you. You'll be sent Zoom login information and additional materials, including any documents we have the day before your shift. If for some reason we're unable to fill your shift, we'll let you know that as well. If for some reason there were no tenants available at the time of your shift, I will tell you that that's not happening very often right now. We have a lot of cases, and shifts are available most days of the week, and all shifts are 1 hour. During the appointment, when you log on to the Zoom, you'll be assigned to a breakout room. The tenant that you're assigned to talk to will be sent to your breakout room when they arrive. You will start the appointment by going over what we call the Statement of Understanding. It's provided in your materials, and it lays out the relationship between you and the tenant, and it makes clear that we have not agreed to represent the tenant any further, right? And that they are responsible for appearing at any future court dates. Sort of your nice little safety net. You put on your seatbelt before you start the case. You'll note the client's verbal consent to the Statement of Understanding in your notes. You'll proceed with the interview, and of course, we provide you a checklist. The most important thing that you'll figure out when you're talking to the client is, what do they want? What is their goal? How would they like to see this resolved? Do they want to stay in the unit? Do they want to move out? Are the most common type of goals that we're really looking for. We want to know if they negotiated with the landlord and what happened. We want to identify any procedural issues or potential defenses. And we also want to ask, of course, have they applied for rental assistance? You'll decide whether you're going to refer to Legal Aid Chicago for extended representation in consultation with the Legal Aid Chicago attorney, But two common examples are if the tenant is living in subsidized housing or facing sexual harassment from the landlord. When you are done gathering facts, you'll leave the breakout room and go to a separate breakout room and consult with an attorney from Legal Aid Chicago about next steps. In most cases, there are 4 options. You're going to provide brief advice, you're going to make a deal, you're going to make a referral for extended representation somewhere else other than Legal Aid Chicago or to Legal Aid Chicago, or you'll tell the client to return to the next court date via Zoom before the judge and advise tenants of the rights to file a jury demand. Usually brief advice and telling them to go back to the court for Zoom are in conjunction. You're not going to tell them to go to Zoom without for trial without providing them some brief advice on how to proceed. If you are interested in negotiating with the landlord or the landlord's attorney, you can identify the plaintiff by examining the complaint, which should have the plaintiff's attorney's or the pro se party's phone number, and we'll actually probably have it for you. If you call them and there's no answer, of course, you can leave a message and ask for a callback. If you are unable to negotiate in that time period, and that's the only time you have to negotiate, just consult with a Legal Aid Chicago attorney because you might be able to leave their phone number for a callback. If you are unable to locate the contact information or you're unable to engage in negotiation and you feel like it's a strong case, you can make a referral to Legal Aid Chicago by letting the attorney in the Zoom know and making a notation in your notes. And if you feel like it's not a strong case for negotiation, you can provide guidance to the client on next step and also give information about free mediation services available through the Center for Conflict Resolution. So we are there for you at every step. We provide you checklists and guides and real-time support. And you can gain experience in client counseling and coaching and negotiation and really help someone. And by giving advice to renters or negotiating on your behalf, you can empower them to self-advocate, connect them with needed legal assistance, and help them to stabilize their housing. So my contact information is here. If you have additional questions about volunteering or landlord-tenant law, please feel free to reach out to me. And I hope you will join us in this very, very important cause.